Members present, myself, David Lorman, and Charles Myers. We do have a quorum. Comments from citizens present. I did not see anyone online that wasn't part of the meeting as advised. Do we have anyone online who wishes to speak or address the committee?
I don't see anybody.
Okay. Hearing none, we'll move on to the approval of the minutes. I did not get a copy in the packet of the minutes from the last meeting. No, that's we can we just go, I will move that we defer the approval of the minutes of the January meeting to our March meeting.
Second.
All right, we have a motion and a second. All those in favor, please indicate by saying aye.
Aye. Aye.
Aye. Motion carries unanimously. Item number 1, hearings and appeals. The appeal for an operator's license from Leonardo Mendoza.
All right, and Kim, I forwarded you the information from Tenley. Leonardo is here. I'll ask him to unmute here. This was denied due to an unfavorable police report. I believe he did not disclose a few items on his application.
Okay.
So this is my first appeal, so since I've been on LNO, so I don't know how you guys do that. I'll let you take the lead.
Hi, Megan. So, is this just a matter of failure to disclose, or do we have a issue? 'Cause I don't know what offenses there were.
Um, they sent me an email just late this afternoon. Um, he had,
Are you able to forward that to me?
yeah, I'll forward it to you as well. All right, it's on its way.
So if we have, yeah, I mean the failure to mention and complete the application is one issue, but then I think all of you members have been part of this discussion at least once before over the last year, but maybe I'm misremembering. Um,
You're accurately remembering. We had
okay,
one discussion regarding a denial and appeal in
right. So as you know, there are several, depending on the nature of the offenses, there's several things that we have to consider. One is whether the offense relates to the licensed activity, and then also we have to consider whether if it is related to the licensed activity, whether there's any evidence of rehabilitation. So let's see. I'm trying to figure out what I don't want new things in Acrobat. I don't want to try anything new. Why are you doing this to me? There. So that is 2018. Bill charge. So there's a disorderly conduct charge from 2018. Um, amended by the prosecutor. So it looks like convicted of just a citation offense rather than a criminal offense of disorderly conduct. An offense in 2018, conviction in 2019. It looks like that had something to do, potentially a domestic abuse situation. So we probably want to find out something about that and whether it relates to the licensed activity, a 2020 offense. Sorry, I'm not really good at reading these reports. It's a little all over the place. Yeah, it looks like several charges arising out of battery, disorderly conduct, knowingly violating a domestic abuse order, strangulation and suffocation charges. Just trying to find out if there's a conviction. Information file. All right, so there looks like there was some of these dismissed, but there was a sentencing on a couple of these offenses. Probation ordered, as far as I can tell. Probation. It is hard to, well, let's see, other charges out of 2023. Looks like. Disorderly conduct. Non-criminal disorderly conduct conviction. It looks like the charge on 2023, convicted in 2025. Let me see if I can get I'm gonna try checking CCAP to see whether I can get a clearer picture of the conviction history. Like these reports are difficult to read just as they're printed because you have to match the identification numbers to the charges, and sometimes they have additional entries. But it looks like a series of basically disorderly conduct, domestic violence related offenses over 2018 through 2023. And it's my understanding those were not put into the application. Is that correct, Lori?
Correct.
So I'm maybe checking CCAP for maybe a clearer picture of exactly the extent and nature of the charges. Maybe this would be a good time to hear from Mr. Lozada about, one, why they weren't listed, and two, what the nature of the offenses are and why they shouldn't be relevant to his operator's license.
Leonardo, are you there? Oh, there he is. Okay.
Can everybody hear me now?
Yes.
Okay. So I was under the understanding, after I finished my probation, that those were going to be expunged from my criminal record. And this is the first time I've had to apply for anything since those incidences. So I wasn't aware that I had to list them. So my apologies on that.
I did notice mention in one set of those charges the possibility of expungement. I don't know that expungement has actually occurred, and it's not clear to me that that applies to all of the things. I'm sorry, it's Mendoza. All of the charges that are reflected here. Hold on here. Although when I look on CCAP, the only thing that's coming up is a civil offense.
Yeah, so I was under the understanding they were going to be expunged, and I've never really had any issues in the workplace. Like I said, this is only pertaining to one relationship that I've had in the past. Obviously, lessons learned, so hence why I didn't list it in the application.
Hmm. Well, yeah, there was even one of these disorderly conducts comes just this last year, July 25th, or July 25, July 3rd, 2025 is a disposition date. I'm not seeing any subsequent expungement of that.
That was the different situation.
Was that identified in your application?
I don't believe so because the charges were dropped and I was just charged with a civil forfeiture, which is just in the city ordinance, I think. Well, it's nothing criminal.
Well, I think the application though asks for any.
Yeah, Matt, the question on the application, as it's included in our packet, is have you ever been arrested for uh received a summons to appear in court for or paid a fine for any of the following for multiple charges, attach additional pages. And those appear to all be alcohol or oh no, disorderly conduct is on page 3 as an inclusion, and the application lists it no.
Hmm.
I mean, that's my reading of the application as well. And we had a previous individual come through who also did not disclose that information on their application, and their application was subsequently denied because of it.
Okay, so is there any way I could just reapply and just include whatever it is I need to include in there?
I think that's a question for Lori. Lori?
Oh, I think somebody has done that in the past. One of the last ones did reapply, and then it was approved, yes.
Yeah, now if you know if
Okay.
I'm still having trouble reconciling the record that you forwarded me from the police department and confirming expungement of all these cases. Although, like I said, when I searched just Mr. Mendoza's name on CCAP, I'm only getting one civil case. But even the citation that was just issued that wouldn't have been expunged should be there.
Matt, I think Tenley said that she had to search using he has two last names, is that right? That starts with a
Yes,
Q?
correct.
Oh, I see.
Yeah.
Well, let's see what that does for us. Okay. Yeah, that shows a lot more. Yeah, I'm not seeing. So on one of these cases, I see, yeah, it's the 2020 felony case. I see a plea to 2 misdemeanors, 3 other charges dismissed. I'm not seeing any evidence of expungement in that case. I'd have to go through each of these to see what there's any other reference to that, but I mean, I think there's clearly some that should have been on there. I think if you reapply it, I think we want to make sure that we have a detailed review of this, and maybe before you reapply, I would double check and make sure you know exactly what the status of all these convictions are. And, if you can show that it was, you had some reason to believe that they were no longer out there, the committee can take that into account upon a subsequent application.
Matt, I think the ordinance says something regarding, I'm just looking at it here, that the License and Ordinance Committee can reconsider the application as it is, and and
Well, yeah,
decide.
no, I mean, it's certainly an option as well. Yeah, I didn't mean to
Yeah.
suggest the denial was the only option at this stage.
Right. And then the committee can decide if they want to approve or deny his application.
Right.
And then if denied again, it could go to common council for review.
So, yeah, I mean, at this stage, it seems like we have two options. We could, well, either deny and reconsider at a later time if he wants to bring it back and asks to reconsider based upon additional evidence. Could deny it and have a reapplication. I think under either of those scenarios, we need to, he needs to know, and we need to know exactly what the status of those past ones and whether was good reason to believe that they didn't need to be listed. I'm not finding conflict.
Yeah, I can probably grab a document from my lawyer or something, because the last time I spoke with anyone in regards to that was at least 2-3 years ago. Like I said, I haven't had any issues applying for anything. So it was my apologies for not listing it. But yeah, I'd like to go on with whatever is fastest, because I just want to keep working at Craftsman. I've just been working there and just getting out of trouble and stuff. So whatever I have to do to make that process quicker, I'd appreciate that. Not do whatever I need to do.
So I don't know if the committee has any other questions of Mr. Mendoza or me, or has a particular approach that you'd like to.
So I have a procedural question,
Yeah.
Matt. If we vote to deny Mr. Mendoza's application in the interest of remaining consistent with a policy choice that we've made as a committee, would we be able to do so while encouraging Mr. Mendoza to amend his application to be complete for his appeal to City Council? Because procedurally, the denial and appeal would be the fastest way, I think, for us to get there. Otherwise, there's the potential for a month.
Yeah, I mean, I think he needs a complete application before you'd go to the council. Yeah, I don't think it works to amend the application in between the denial and appeal. So I think a complete application needs to be considered by this body, either on a reapplication or a deferral to give Mr. Mendoza the time to update his application. And then also, if it gives us time to better confirm whether there's any grounds here because you still have even with the amended application, I think you still need to make some judgment on whether rightly or wrongly there was at least an arguable basis to conclude that you need not have put these on. I think if we just say, you amend the application, and that's it, without making some judgment as to whether there was some reasonable belief behind not including them in the first place.
So you're saying he could amend and then bring it back to LNO? So defer so he can amend it and then bring it back?
Right. I think if he appeals a denial here, he's appealing the denial of what is admittedly an incomplete application, which I don't think is what he wants to do. I think he wants a decision from this committee on a complete application if he thinks a complete application still entitles him to approval, which is the second question that I have here. There are a number of offenses here, and I so far can't. Yeah, so it looks like at least on one of these, there is a note here that court finds defendant eligible for expunction. That might be. I'm not sure if that applies to all of the charges, though, or just one of them. It's not clear to me from reading this. But that again appears to only apply to the 2020 charges, and there are at least two forfeitures, two other forfeiture charges filed in 2024. Well, that's just a dog license. Possession of THC is the other one. 2024 FO 254. Yeah, 2022 disorderly conduct case. So
I had one question. This is not a renewal, is it? I mean, Mr.
I've had a
Mendoza
liquor
hasn't,
license, or I guess serving license through Fitchburg, the city of Fitchburg before.
Okay.
But that's
but not
about it.
Middleton.
Correct.
Okay.
so I guess, yeah, do we want to, I guess, move to defer to consider, give them a chance to complete the application and reconsider it next month, or deny it and leave it up to Mr. Mendoza to either appeal what is, I think, an incomplete application, or file a new application with all the information. Those seem to be the choices as I see them.
Well, if I get denied, would I be able to apply and I guess get approved or denied before the next month? Because I mean, right now all I'm doing is bartending, so they took me off the schedule for the next 2 weeks, so I'm not working anymore. And if I'm just gonna postpone not getting the license, just for me to if I'm gonna reapply and then get denied again, then I see no point in that, right?
I see your point. I guess it's up to you to decide whether there is any point. And I guess, the other thing too, I don't know to what degree we want to get into, but I mean, we do have other offenses that upon reapplication, you'll need to consider whether or not, they have any bearing on the license.
Right. So I guess what I'm asking is it faster for me to just get denied? Like if I get denied right now and I can reapply tomorrow or Monday or whatever, would I be able to get that acceptance or denial before the next meeting?
Well, what'll happen is well, unless the police department doesn't find any issues with these offenses and you have listed them, it's at least, it seems unlikely, but not totally inconceivable that the police department and the clerk push this through, but with several disorderly conduct violations and a THC violation, I suspect it would get denied, and then you'd be back before this body next month. Regardless. So I long story short is I don't know that's a quicker route, save for the slim possibility that the new application could just get approved, but
Okay.
I do think for the sake of consistency, because we've gone down this path with other applicants, that we maintain our position of denying the application and have the applicant go ahead and reapply a complete application that the city clerk and the police can look at and then come back to us if we need to at the at next month's meeting. Again, I might be a stickler for consistency, but I would prefer to go that route for that purpose.
yeah, that makes sense.
So motion is,
So my next step
sorry.
would just be to reapply then.
Assuming this motion gets made and seconded and passed, yeah, that would be the route.
Sounds good.
So the motion is denial of application due to it being incomplete.
Yes, I will officially make that motion.
I will second that motion.
All right, we have a motion and a second. All those in favor, please indicate by saying aye. Aye,
Aye.
motion carries.
And I have a quick question on that then, Matt. So if when he does reapply, if the police department approves it, then I can just go ahead and issue, or does it
Yeah.
still need to come back to L&O?
No, yeah, it's a new application. Like I say, yeah, it's not inconceivable, but like I said, given there are at least, I think, 4 disorderly conducts or at least 3 disorderly conducts and a THC violation. I don't think any of them are criminal, so yeah, I don't know exactly what the police department will do with that. So it's not inconceivable. And if they're fine with the background check of those particular offenses, you can approve it.
Okay, sounds good.
And if not, then we'll consider the offenses under the standards next time.
All right.
Did we vote?
All right, thank you, Leonardo. I'll watch for that to come through then, okay?
All right. Thank you guys for your time. Have a good night.
Yep, thank you.
Thank you.
Good night.
Did we vote on that motion? Did I miss that?
We did.
Yes, it
We did,
carried
okay.
3-0.
All right.
All right, we'll move on to ordinances. Item 1, ordinance to create section 6.10 to establish age restrictions on hemp derivative THC products.
Okay, yeah, this.
I do have a statement from Tyler at the police department on this. He sent me since he couldn't be here. Do you need a motion to discuss first, or should I go ahead?
No, go ahead, Lori.
Okay. He short of the long of it here, he said the PD is in support of it. They seem to have some issues at our local businesses selling at least 4 of these materials. They're concerned of further issues and activity being funneled to our city if we don't follow suit with Madison and Dane County, given they recently passed a similar ordinance last November. And the public health of Madison and Dane County are also in support. Last week, they did a compliance check, and Fox Tobacco and Vape sold to one of their youth inspectors and then that's why they brought this ordinance forward. However, they did not give a violation last week, but they would have if the ordinance was in place. And that's it from him.
So I think, yeah, I think it's pretty clear this is something we need to look at because, yeah, with other communities adopting similar prohibitions, you don't want Middleton to become the underage hemp mecca, or maybe you do, but I don't think you do, of Dane County. I would say there's a couple things that I think in particular you just may want to think about, and that's in the location restriction. You see, we selected the 1/4 mile or 1,320 square or feet away from how we define youth serving businesses. Much of this ordinance is basically pretty well patterned after what Madison has adopted. There are other communities that have different distances, some shorter, I think. And Katie can correct me if I'm wrong. This is probably the furthest distance, or one of, amongst the ordinances we looked at. She's given me a nod, but so I don't have strong feelings one way or the other, whether you feel that's too far or too short. Then also we mirrored that whatever distance there is, that if there are existing businesses within those distances, that they are essentially grandfathered from that distance. I'm not sure that is absolutely required. I don't think that anybody has any constitutional right to sell hemp hemp-derived THC products, but certainly if a business has been doing something that it's, that's the choice that Madison made. What we would do here is that basically after we adopt the ordinance, the date would be whatever the effective date the ordinance is, and we'd put that date in with the ordinance we send up to our codifier. We'd insert that later, but if you wanted to do something else in that regard, like require that or grandfather them to the extent of existing supplies, at least theoretically, that's an idea, although, it's also quite difficult to enforce or, and you got to
Yeah.
go look at records, invoice, how do we decide what somebody's inventory was on a particular day? That could get a little bit involved. So I'm not necessarily recommending that, but throwing that out as a consideration. And I've got no idea how many or whether there are any existing businesses selling this type of stuff within the radius that we identified.
Charles, you had your hand up first.
Yeah, I did. Um,
Sorry, I can't see hands.
oh,
the phone.
okay. All right. I'll just sorry.
fun.
I'll start speaking then. Um, okay, first, thank you for the work that you've put into this particular ordinance. I actually support the larger distance. If we were to make this ordinance consistent with, say, the distance for notification for landmarks elsewhere in city code, the gas station across the street from my son's daycare would be able to sell these products, and that's not necessarily something that we'd want, or we'd just strike that particular provision in the ordinance. I had a question in the definitions section because these particular products tends to get created in an effort to capitalize on the slower pace of legislation. They use chemically similar compounds and update them frequently. I would want the definition section of cannabinoid. I am sorry, it's been a long day. I would want the definition section where we define hemp-derived cannabinoid to have a process for administrative updates by the police department based on lists maintained either by the federal government or a state law enforcement agency, or lists maintained by neighboring municipalities, just for the sake of consistency. That way we're not having to monitor this particular ordinance for chemical compounds that are just isomers of these various things. Just to be clear, I actually support full legalization here, but legalization also comes with responsibilities and for responsible use and sale. So
I think we probably have a legal problem with I don't know if that's a definite enough standard. Well, one, essentially tying our standard, we're going to do what somebody else is doing, I think is legally problematic. I understand your point, and if, I think we maybe could try to consider what some broader language might be in the future. But I'd want to give a lot more thought to how we open that up. I mean, one of the, you rightly identify that, some of these things try to just stay ahead of what the legislative process is, but the legislative process for the city is not the legislative process for the state or I mean, if the police department or somebody identifies something, or we see other ordinances are adopting other expressions of this, I mean, we could have an amendment to this within 30 days, expanding this. Because the other problem too is I don't know that saying that we're going to update this someplace else, so that it wouldn't be updated within the ordinance, it would be updated in some document that isn't published elsewhere, and then that creates potential notice to potential defendants that they don't know what is actually prohibited by the ordinance, because it will occur according to some process that is not necessarily clearly defined, but most importantly, does not create a publication necessarily of what the offense really is. So I would, I would recommend that we leave this as is, and maybe give some thought to how we can be a little bit more flexible, but otherwise rely upon just the fact that we can be more nimble than our state legislature in updating our regulations, and do it that way. I just fear that there would be all kinds of headaches in the prosecution of some type of chemical compound that isn't reflected some way in our ordinance. And I do think that this does add some breadth, as long as is an isomer derived from such cannabinoid. I consider the list that follows to be examples, not a exhaustive list. And maybe to make that better, we could improve it by saying, instead of just using a parenthetical, say including but not limited to. I think that would make it more clear that that's not intended to be a comprehensive list.
Yeah, I'd be comfortable with that. I just want to make sure that we're as nimble as possible and we're not having a monthly update meeting as a committee for this ordinance, if at all possible.
Sure.
And I appreciate your suggestions and willingness to work with us on this, work with me on this, because I trust your judgment, Matt. And thank you for the fine, because you mentioned the issue of enforcement. Elsewhere within the city's general operations, we include provisions for liquidated damages related to the enforcement of certain ordinances. Would we be able to tack that on to the $700 set in the schedule?
No, this would be an offense that be prosecuted in municipal court, and really you can only get whatever we've set for a forfeiture. Restitution may be available, but this isn't a property damage type of thing. That's municipal courts can order restitution, but damages outside of what is identified as the penalty for an offense are not awardable in municipal court.
Okay. In that case, what's the highest fine in Dane County?
I'm not sure if we know that. Katie, did you see any range of forfeitures?
I am looking it up now, but I believe it was 500 to 1,000 was the range that I was seeing throughout the state.
And one thing you should understand too, so these numbers here, this is the base forfeiture. So that's not the amount that you pay in municipal court or get written on the citation. So for every forfeiture, you've got statutory costs and fees that get added. And so, for instance, the bond schedule that I'm looking at here this one goes to $300, but I'll just give you an example. A $300 deposit amount actually translates, if you have a $38 court cost with all the other fees, as a $439 forfeiture. So I don't have the information to extrapolate that up, but I just kind of usually I don't want to choose something that's the lowest fee because you want people to just pay it. But or you don't typically want the highest fee because you just want it to pay it, but you don't want it necessarily the lowest either, because usually if people just pay it, there's no other action that happens in a municipal court. And this is, of course, also for, each offense and each day is an extra offense that can be cited. But that said, I think under section 3004, the penalty that could go up to, let me get into our ordinances here. So for first offenses, generally, our first offense penalty the absolute maximum is $3,500. And so that could still be what gets ordered potentially, depending on how you choose to prosecute it. But right now, as this is drafted, what would get written on a citation is $700 plus cost, which probably comes out to a little over $800, maybe. Could be 900. Well, no, actually, probably is going to be somewhere between $900 and $1,000 is what would be written on that citation.
Okay, thank you.
Matt, I have a question regarding location restrictions. So for example, liquor stores, a liquor store can be within a quarter mile of a school or youth center or daycare. Now, that's because to sell liquor, you have to be a licensed business. Obviously, we know there's an age restriction. So with an ordinance like this, where there's going to be an age restriction put in place, but clearly communities haven't developed any kind of licensing to sell this kind of substance. Is it, does it matter the fact that you can sell liquor where you want, but this would have to then be further from a school or something?
Well, no, I mean, legally, it doesn't matter. I mean, I understand your kind of idea that, is there some reason why these should be the same?
Yeah, I'm just
I mean,
sort of thinking.
I certainly think, short answer is it's entirely a policy decision.
Yeah, gotcha.
There's no legal reason why we have to treat these the same. Sitting here can't articulate. There may be good policy reasons why other communities have chosen to treat this differently. I mean, I believe that this general setup, like I said, this is primarily Madison's, but I don't think there's a ton of wild variation out there on these.
Yeah.
These all the ones that are getting adopted seem to more or less follow this pattern, and that's for better.
Yeah, like I think of Lakeview Park. We got a liquor store across the street from Lakeview Park, and there's a one of those kind of vaping or whatever stores next to the liquor store across from Lakeview Park. I don't know the name of it, but it's there. I think about these products. Some of these products have started showing up in more also, let's call it alternative pharmacies, where it's not their core business,
Right.
this type of product, but they do sell. Some of these places probably have some CBD oil products that may have THC in them, some may not. So I'm just wondering how places like that would reconcile with this moving forward.
Well, as drafted, existing ones could stay where they are. So
Yeah.
it's not, that's probably one reason for other communities having balanced all those concerns in this way, is that, they know they've got some existing businesses that have this incorporated in their business model. And now, to be clear, you know, unless it is a significant part of their business, we're not saying you got to close your business. If you didn't have that grandfathering, it just means you couldn't sell this stuff at the store. But at any rate,
Yeah, I mean, I have no idea. I frankly have no idea what,
right. Well,
you know.
and I unfortunately, to some degree too, I think that this is something that we've just found ourselves having to catch up to. And, maybe this is something that after we adopt it, we go and give some more consideration to. But, right now, we're kind of exposed as the community that has no such regulation, which creates, I mean, I'm not saying this absolutely has to happen tonight, I don't think, but it does,
Yeah, no, I
it
didn't
does create
realize
an
that
urgency.
I didn't realize that a minor could buy these products. I had no idea.
Yeah.
So, um, I figured there would be some kind of age cap on something like this. I just didn't realize that myself. So I'm being educated on this as well.
Yeah, I think Dave, I mean, I'm generally sympathetic to your point that willing buyers and consumers should be able to, conduct business for comparable intoxicants in similar ways in terms of treatment of these versus treatment of liquor stores. The difference that I see here is that with regard to this specific type of product, liquor has an entire state regulatory program with regard to licenses, with regard to distribution, with
Yeah,
regard to
exactly.
all sorts of other things. And so if we were to ever adopt an ordinance uh, that was substantially identical in terms of location and other treatment to our ordinance for the sale of liquor, we'd need all of those other pieces of state enforcement infrastructure, which simply do not exist for this class of product. So I
Right,
think,
right. And
yeah,
that's why I'm thinking, other states where THC has essentially been legalized, those businesses have operators licenses, I would imagine.
Yeah, it's a pretty highly regulated industry and
Yeah.
significantly,
So people like us with this type of thing, we're kind of living in this in between zone of it's like NA beer, it's 0.02% alcohol. If you drink enough of it, you might get drunk. But you got to drink a lot.
yeah, but it's precisely because we're in this regulatory gray area that I want us to be more restrictive in this ordinance until things are a bit more sorted out at the state level and regionally, and that way we can, as
Yeah.
needed in the future, relax the ordinance in places, tighten it up in others. But I just want to make sure that when we get this passed, that we're cautious with public safety for the community.
Yep. I hear you. All right, you've answered my questions. Thank you.
All right, Charles, do you have a motion with regards to the change in language and definitions?
In definitions, I haven't been able to think of a great one. But Matt, you had a preferred approach. So if you want to,
yeah. So if you want to make the change I suggested, I guess the motion I think are looking for is a motion to recommend approval of the ordinance with the definition language in section 1A1 to reflect that it's a cannabinoid other than Delta 9 tetrahydrocannabinol THC or an isomer derived from such cannabinoid. Insert there, including but not limited to, and then go on with the rest of the language.
That is my motion.
I will second that motion. All right, we have a motion and a second. All those in favor, please indicate by saying aye.
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 Motion carries. Discussion items, number 1, review of license fees.
Yes, this is mine. I had recently talked to Matt about incorporating background checks into some of our licensing fees that we currently charged. The police department used to provide the background checks for us, and now I believe they're using some other program or database that when they go out, they get charged $7 for every background check, and then that's getting passed on to our department in the licensing fee category here. So I was hoping to change some of the licensing fees, and then Matt mentioned, well, we haven't changed any of them really for a while. So I kind of did a review of everything that we currently have. I did some comparisons to some other communities, and then I came up with just a few changes that I would recommend in your packet. Did I include that sheet in your packet?
You did not.
No,
Oh, I didn't. Oh, I didn't. Oh, shoot, sorry.
Oh.
it's a very
So-
thin packet.
What was that, David?
Not a lot in the packet.
No, okay. So one of them was the direct seller's fee. So currently we charge $50, and it's for a whole calendar year. In looking at some of the other communities, they have done a monthly, they charge a weekly fee. Weekly or monthly looks like the most popular. Sun Prairie does have an annual of $300, where we're charging $50 for the whole year. So I was proposing that we do $100 fee for the whole month rather than dealing with weekly fees, which could get, because some of those, it just depends on the weather when those people are going door to door and selling roofing and whatnot. They might not get their job done in that week. So I thought maybe more of because then we'd be constantly issuing them, right? So looking at something like $100 for the whole month for direct sellers. And that would include the background check fee. So Matt had suggested that we just increase our fees and then include the background fee in the fee itself rather than having a separate fee.
Yeah, so all the things you listed for, I did maybe to get some context. I think, certainly for direct sellers, I think we have some room in the operators as well as the mobile food carts. Cigarette licenses are the statutory maximum is $100, and also most of our retail licenses, other than retail class A, are maxed out under statute. For some reason, retail class
Right.
A beer licenses, they don't have a minimum. I would say I do think we need to double check with the police department though too, because there is depending on where there is a $7 charge that the Department of Revenue is permitted to charge, and that, according to Revenue's regulations, is a fee that can be in addition to whatever else is charged. Because the way the administrative code reads is that it's charged by the department to the applicant. Now, whether
Mhm.
whether literally the department collects it from the, I don't know how that happens, but it is accepted. So we could do something potentially there if that is the sort, if that's where they're getting the background check done. If it's someplace else, though, I'm not sure we have that leeway to tack that fee on, because it's only that DOR fee that is expressly added by the statute. But for all the other ones, yeah, I mean, I think we just want to look and make sure we have a fee that covers our total costs, and I think it makes
Right.
sense to have it all just wrapped up into one fee.
Mm-hmm. Now, did you want me to just send you, Matt, what I recommend we increase these fees to, and then you drop the ordinance changes and then it comes back to committee, or do you want me to let you know now what I'm thinking? It's
Well,
up
I
to
guess
you.
we would leave that up to the committee, whether we'd like have the committee give me some direction now on how you feel about these fees, or whether you'd rather just see a proposed increase all in ordinance form.
I'm not comfortable voting on raising fees without having it in front of me
Okay.
in a written document that I can
Right. Yeah, it would definitely have to still come back. I just wanted to see if you wanted to hear my recommendations, or would you rather discuss it when the ordinance comes back then? Yeah, is what I'm hearing.
I'm more comfortable with that, yes.
Yeah.
Okay.
Yeah.
Okay, yeah, I'll send these over to you, Matt, then. Um, what I'm thinking, and then we'll discuss it on the next month then.
Okay.
Okay.
I have a question for Matt because
Yeah.
the cigarette license came up and the fee for it. Did we intend to write that ordinance in such a way that you need to pay the city $100 if you're sharing a cigarette with your friend outside of a bar?
I do not think that is probably the intention.
Because we've written it that way.
Let's see. Yeah, I mean, this has probably been on the books from
1970.
Just food for thought.
Yeah.
We
I'll have
can't
to see.
really.
I wonder if that mirrors the statutory language or where that came from. Well, I'll make a note to take a look at that. But yeah, it does seem that if you bum a cigarette, you may need a license for that, unless there's some other exception there. See what you find when you actually read your ordinances and interesting stuff.
Sorry to interrupt with that. It's just
Oh.
I was looking at it and said, "Oh,
Right.
that seems kind of restrictive."
Well, things will kill you. I call them coffin nails for nothing. So, maybe we.
Yeah.
Coffin nails. I don't think I've ever heard that before.
Okay. Duly noted. We'll take a look at that.
All right, are we ready to move on to item number 2, the discussion regarding potential ordinance amendments to expand anti-discrimination protections?
Okay. So yeah, this was I'll let Alder Byers kind of
Yeah.
discuss a little bit more of ideas. I mean, just right now, all we really have, I think this discussion between us initially came out with some questions relating, can we add things much like our equal benefits ordinance? And right now, really in our ordinance is the only place we have express anti-discrimination is in our personnel ordinance. We don't have any other express contracting requirements similar to the equal benefits ordinance, and certainly don't have any like housing discrimination enforcement stuff and all that. And so this is where I'll let Aldermeyer see where kind of the scope of his ideas we're going
Yeah.
to.
So, and Matt, you touched on one of the reasons that I brought this up, which is that I want to make sure that we have non-discrimination protections which uh, take as strong a position as is legally defensible post Bostock in our ordinances for the protection of individuals who are transgender, but also because the city is going to be taking up some number of endeavors in the affordable housing space in the very near term. I think that it is important for us, to the extent that it's practical, to make sure that we have non-discrimination in housing ordinances on the books, so that we're not just defaulting to state law, but we're being as protective for vulnerable populations as possible. Does that make sense?
Well, right. Yeah, no, I think that does make sense. I think the question then becomes is, the scope of what we're looking to do. For instance, are we looking to, limit our enforcement to housing projects where we provide any kind of financial assistance? Are we looking at a broader housing discrimination enforcement regime? That of course considers, potential personnel additions or changes of duties. That's can be a fairly significant additional undertaking.
Yeah, it definitely can. I think that at a minimum, we need to adopt something with regard to projects that we have in some way financed with our affordable housing fund. I think that's a good place to start. And you can correct me if I'm wrong, Matt or Katie, but if we are using our money to finance those, we may have more tools in the toolkit, so to speak.
Yeah, I mean, certainly, I think we could, yeah, if we're giving direct financial assistance, that gives us some monetary remedies that, put it in this kind of a form of liquidated damages or contractual, much like we do with the equal benefits ordinance. We kind of have a defined percentage of the contract amount or something like that, where you can claw back some degree of what has been provided if there's a violation. I think those things can be considered.
Okay, and I think, look, I'm just checking here. Yeah, this is ordinance amendments only, so I'm not going to discuss city contracts.
Well, unless you wanted to talk about an ordinance amendment that would require certain things in city contracts, but
Would that make your job easier, Matt?
I don't know. I'm not here to make my job easy. I'm here to give you what you're looking for.
Well, let me rephrase.
Sure.
Given that I am looking for the city to be as protective of vulnerable populations and discrete and insular minorities and other populations that could conceivably suffer from the effects of discrimination, would it make your job easier as our city attorney in preventing discrimination against those groups if we had an ordinance with regard to city contracts or not?
Well, I guess that, I mean, I don't know that the folks with whom we are contracting are maybe the biggest violators of equal rights issues. I mean, I don't know that they're not either, I guess, but yeah, I don't know that that's the place where I would at least personally suggest that, yeah, we're really going to move the needle if we make sure we've got our own binding provisions. I would hope and assume that most of the folks that we're dealing with are following state law, which, while may not expressly extend to the same people, at least currently, I think the interpretations from our existing attorney general extend them as far as you are looking for. I do think it makes sense to the extent we're talking about housing, largely because we're giving the additional money, but broader impacts in the community, I suspect may take a regime that's going to require personnel, more administrative tasks and so forth, that's going to carry maybe a price tag with it that I don't know if,
So would you feel, and I guess would my fellow committee members feel comfortable requesting that Matt put together a non-discrimination in housing ordinance specifically related to housing that we use affordable housing funds to finance?
I'm comfortable with that.
we'll try to throw something together and bring it back for you to look at.
Yeah, thank you so much, Matt. I
Yeah.
appreciate it. It's a broad and complicated and changing area of law. I just really want us to get this ironed out before we start potentially distributing funds.
Sure. No, understood.
And when I say housing, please include service organizations in that, because the contracts for service organizations typically do go hand in hand with affordable housing dollars.
Right. Okay.
Any further comments from committee members regarding discussion item 2? All right, hearing none, we have reached the end of our published agenda and this meeting is adjourned. Thanks,
Thank you.
everybody.
Good night.
Good night.